started, everyone. Good morning, and thank you to everyone for attending today's event. My name is Katie Takeuchi, and I'm a 3L here at Notre Dame Law School. Today, I have the great privilege of introducing the Assistant Attorney General for the Antitrust Division of the Department of Justice, Makan Delrahim. Mr. Delrahim, thank you so much for being here today. I'd also like to thank all those who made today's event possible: the Business Law Forum, the Future Prosecuting Attorneys Council, the Intellectual Property Law Society, and the Research Program on Law and Market Behavior. I'd like to especially thank Professor Alford, who has been integral in planning this event. Professor Alford will be moderating today, and he recently served as Deputy Assistant Attorney General at DOJ Antitrust. Mr. Delrahim's impressive background certainly led to his 2017 confirmation as Assistant Attorney General. Early in his career, he was Antitrust Counsel and later Staff Director and Chief Counsel of the Senate Judiciary Committee. He also has previous experience with DOJ Antitrust, having already served as Deputy Assistant Attorney General. To add to his list of qualifications, he is a former partner in the LA office of a national law firm, and he recently served as Deputy Assistant to the President and Deputy White House Counsel. The Antitrust Division promotes free and fair competition in the marketplace. It touches virtually all industries, and it files both civil and criminal suits. This past summer, I was a slip intern in the Antitrust Division's Criminal 2 section. I found the work to be challenging, complex, and extremely sophisticated. It was, without a doubt, the best experience I've had in law school. Mr. Delrahim runs the division phenomenally well. He is very fortunate to have some of the best attorneys I've ever met working there. Now we're all here to hear Mr. Delrahim speak. I'm going to let him do so. Please join me in welcoming him.
So I'm going to be moderating with my good friend Makan Delrahim. Makan and I go way back to the mid-90s, I think, where he was a law student at GW and an intern in Judge James Buckley's chambers. And then has just an incredible, illustrious career. And then we overlapped again in 2008 when he was a partner at a law firm in LA, and I was a professor at Pepperdine. And so Mike and I have known each other for literally for decades. And when he called me up in March of 2017, one of the main reasons I wanted to say yes was to be able to work with him, because he's just such a really, really fascinating person. Definitely an outside the box person with his a lot of people say Makan stands for making things happen. He really is incredibly energetic and productive. I thought it'd be fun though. I mean, most people don't know your background, and going all the way back, and you were in Iran, and you fled Iran with your family when you were in elementary school and spoke no English when you came to the United States. You want to start with that story?
Sure. Well, first, let me thank you and thank Katie and the law school for inviting me here. It's a great privilege for me. And I want to thank you guys. Boy, on a Friday morning, you have some great students. Had I been a student, I don't know if I'd be coming here to listen to me. So thank you for that. And Katie said a slip intern. Some of you guys may think somebody will slip through the cracks or something, but it is a very prestigious, and it's our honors law intern program for the summer and at the Justice Department, and it's department-wide. It's a great program. I encourage as many of you who are interested in government service, or at least exposure to government public service, to consider that regardless of your area of interest, because no matter what your expertise that you wish to develop, there's going to be a division of the Justice Department that handles that, whether it's environmental law in the NRD or civil rights or criminal or civil, whatever it is. So I encourage you guys to do that. It's a great way for us. It was also my great privilege to work with Roger again, and was very pleased not only that he accepted to come, but Notre Dame allowed him to come for a couple of years. As far as your question, I was almost 10 years old. I grew up, I was born and raised in Iran, my first 10 years. We were going through a revolution in 1979, as you see in various parts of the country. And there was a place, we were a religious minority, in that country that was not very welcoming. And my parents decided to leave for the benefit of me and my two sisters. So we left, landed in Los Angeles, where I went to, started the 5th grade there, not knowing any English, but was very much welcomed. There's a lot of, I probably sensed some folks who said, you're from Iran, get away. And this is right before the hostages were taken. But even through those, the period of time where the hostages were captive, was not a great time to be from a country that is not well liked in this country. But then people realized quickly that the reason that I was in this country and fled was for the same reason that people condemned the current regime and then regime of the country. So as I said at my confirmation hearing, my story isn't unique. Throughout the generations in this great country, we've had folks who have fled various revolutions, East Europe, Latin America, and other places. And what is unique, though, is the fact that this country welcomes so many folks and provides the opportunity for folks to do some of the things that we have had the great opportunity and privilege to do in public service.
Okay. So antitrust law, can you maybe give a brief sort of 10,000-foot snapshot about why it's so important and also the current debate about what role it should play? There's a huge raging debate. Should it just be focused on consumer welfare standard or should it be focused on the broad public interest? So what drew you to antitrust and why is it so important to your economy?
So what drew me to antitrust was I studied the sciences in undergrad and decided to become a patent lawyer. And I love the intellectual property laws and policies because probably same reasons folks like it, it's that it protects and it encourages creation out of nothing. It gives the hopeful entrepreneur the hope to be able to come up, create the next better thing. And it's what our economy and this, I think, one of the great things about the U.S. system has been, it's encouraged that. And we have benefited from it throughout the years. And it probably ties to the first answer. A lot of great minds from, whether it's Albert Einstein or, Pierre Omidyar, the founder of eBay, to, you can name the various immigrants, Elon Musk. Folks fled to come to this country, which provided an opportunity for inventors, creators, artists, writers to come. So that's what gravitated me to intellectual property. As I practiced some intellectual property, antitrust became more apparent to me that it more or less is what allows the free markets to allow that type of creation to continue. It is, a lot of folks ask, what is your job? Sometimes my 9, 10-year-old kids ask me, Daddy, what is it that you do? And I went to career days, and I had to really think hard about how do you explain what antitrust is to 3rd, 4th graders. And I said, I am responsible to make sure that the markets are fair. The actual capital markets, the various markets that allow our economy to be what it is, to remain fair and free from private restraints. So when two people fix prices, it's unfair ultimately to the consumer because they're not getting the benefit of the fair competition that they would get. And so ultimately prices will be higher, product quality will be lower, and the consumer is at a detriment. There's a big debate about, and it's largely around labels, because I think the underlying principle is difficult. If you believe in free market capitalism, it's really hard to argue that ultimately the benefit of competition isn't for the consumer and hence the consumer welfare standard. But there's a big debate, much more academic to get into, that started in, probably in the mid-70s to late 70s, and what's been referred to as the Chicago School of Economics, that provided some basic neutral principles for the application of antitrust law as we see it today.
So when Macon called me to take the job as a deputy, he had a specific project in mind. He wanted to promote an international agreement, a multilateral agreement to promote fundamental due process. We have about 140 countries around the world that have competition authorities, and Macon recognized that we don't have sort of a set of agreements about minimum due process. So his idea was, let's get countries around the world to commit to that. And so over the course of 2 years, we worked together to promote that. In May, it was May of 2000, yeah, 3 months ago, we had 70 countries sign the agreement on fundamental due process procedures. So you want to talk about that briefly and
Sure.
sort of the sort of benchmarks of where things stand on that?
Sure. So antitrust law has exploded over the last 20, 25 years. Antitrust was something that maybe about 4 or 5 jurisdictions were really doing, and were doing at a level that it really mattered or affected business behavior. The US, Europe, Canada, Australia, to some extent Japan, and that was largely it. And then through a number of efforts, including the Justice Department, as well as others, we promoted a greater culture of competition abroad. So we try to encourage why applying antitrust and competition laws in foreign jurisdictions is good for the consumers there, but it's also good for US exports abroad. So if a market is dominated by one market participants in a foreign country, that usually is also an impediment for US exports going there, because you can't break into a system because it's not a free market. So that's different than government, quotas where in trade agreements, but it's not too far away from the ultimate goals of free and unrestricted trade and globally. So antitrust became something that more and more jurisdictions began adopting. I semi-joke that it's been one of our greatest exports out of the United States. But what has been happening now, as Roger mentioned, there's about 140 antitrust agencies around the world in a very short period of time. So the law has been adopted, the policies have been adopted. Its application is really important, because you can misapply antitrust law and say, let's say, there's a lot of debate these days, big is bad. This company has too much market share. We must apply antitrust law and just break them up. And big is not necessarily bad. It is, you can get big if you have a superior product, and we want to encourage that. We don't want to discourage that. You get big by having a more efficient system of production, which lowers the cost, which means it lowers the cost ultimately to the consumer. So the fact that you're big because your competitors have been asleep at the switch, we should not condemn that. However, you can't get big and engage in conduct in order to remain big or gain that market share. And so there's a lot of nuance in antitrust. One of the things that we wanted to be sure of is that foreign agencies are properly applying the antitrust law, so that everybody benefits, not only their consumers, but our businesses and our consumers in the United States. And so, that's been percolating for a dozen years or so. Are foreign agencies applying or misapplying their laws? Are they doing it in a discriminatory fashion against a U.S. company? There was a big case dealing with GE and Honeywell. They had merged. The U.S. antitrust agencies had approved it, but the European Commission had rejected that merger. And that became a big issue as far as the divergence between two major continents. And given that most businesses are global, or wish they were, they try to be, the concern was you'll have the lowest common denominator as far as the application of economic rules. So I had Roger's job as the deputy for international in 2003, 2005. And around then is when I began thinking, oh, does it make sense to have an international norm for antitrust law, and what parts of it makes sense? And that's when I called Roger when I was nominated for this position and said, Roger, do you have an interest? One of the issues that is low-hanging fruit, I think, is the issue of we should apply the procedures, the antitrust law, the process by which each enforcement agency operates. Maybe we can have a multilateral agreement. Many people doubted that we could get such an agreement, but the idea was to get the basic fundamental procedural protections. This is, non-discrimination, some attorney-client privilege, the right to, examine your accuser, the evidence, transparency in the process. And we thought these are fundamental norms, regardless of the type of regime you have, whether you're in a civil law or a common law, whether you have an antitrust agency that's like ours, where you have to go to court to prove your case, or an administrative system. And so we were able to put together a number of principles and work towards that and get that. And as Roger mentioned, in Cartagena, Colombia, in May, we got, almost all of the major, I think all the major agencies, but over, I think 70, 72 right off the bat as founding members. And it continues to grow and more jurisdictions are joining. But the idea was to, let's establish a basic norm that we can agree on and then hopefully build on that.
Right. Another major focus that you've had over the past 2 years is to apply antitrust laws to the labor markets. And in fact, you had a major conference about that issue recently. Can you sort of talk through what are the special concerns in dealing with antitrust in the labor market?
So there's been a lot of discussion that as the economy has gotten more and more concentrated, one of the losers, so to speak, and this is, a hypothesis, an allegation that's been out there, has been the worker. There's been a monopsony effect, meaning that there's as you have less and less buyers in the marketplace, wages have been going down or not growing in step with the economy. So we want to take a look at that. How does labor apply in a big merger? Should we look at labor markets? One of the areas that's been fertile ground for us, and we've been quite active in, both in our enforcement as well as our amicus filing program, has been the issue of where two parties agree to not poach each other's employees or agree to, limit the wages on them. Well, that is just illegal. That could very well be criminal under our criminal enforcement authorities, where two competitors say, we just won't hire. I mean, imagine if Notre Dame and, IU Bloomington said that, we're not going to poach each other's law professors. And Roger can't go over to IU and say, hey, I can earn an extra couple of bucks if I just went and taught there. Or another, or around the country, all the law schools got together and said, we are not going to, we're all going to agree to not hire each other's law professors. That would have a chilling effect. And this happens all around. So, it could be two, automobile repair businesses. They could be radiologists. So why Roger says radiologists is that we had a case where Duke and North Carolina had agreed not to hire each other's radiologists. What did that do? That limited the market for those radiologists to go offer their services at two different local facilities. There was a private case. We got involved as an amicus. We presented oral argument before the judge. Then the parties settled. We wanted to make sure we had the public at the benefit of those efforts, and also to provide a warning to the rest of the industry around the country. So we didn't want just a quiet private settlement to go away, especially after we had been involved. So we actually intervened in that case as a party and became party to the consent decree for the injunctive purposes in that matter. My understanding is they may have settled for multiple tens of millions of dollars. And that's not a huge class of radiologists. So you can imagine the type of damages they were able to prove, like that type of activity. But that goes on probably in multiple sectors. So we did that. We had, you mentioned the workshop. We did an all-day workshop last Monday, 2 weeks ago, at the Justice Department, where we had that presented. So, you have these issues in multiple areas, including there's a big antitrust case going on in California between the talent agencies and the Writers Guild and the other talent guilds that are suing each other for antitrust. And it'll be interesting to see what develops from that.
Another major focus that you've had is sort of rethinking antitrust in the sports context. You spoke here last year, you gave a major speech on antitrust in the sports context. A lot of stuff has happened in the past year, including, the new California legislation, Fair Pay to Play Act in California. You filed amicus briefs involving antitrust in the sports context. Do you want to just sort of give your thoughts on some of the developments in that regard?
Sure. So it was a fun speech to give on sports and antitrust. It's an interesting area, but antitrust and sports have been together for a number of years. It was in 1973 where baseball's immunity from the antitrust law was reaffirmed by Justice Blackmun at the Supreme Court.
No commerce in baseball.
They said baseball does not engage in interstate commerce because it's just a sport.
Pastime.
Yeah, that's what it is. And such is as it continues. And so they benefit from an implied immunity. NFL has actually a statutory exemption for the pooling of broadcast revenues. And each sports league has had to deal with antitrust laws. The NCAA has been no stranger to antitrust. They've had a major Supreme Court case, and more recently a number of cases where the students have challenged the broad rules that have applied to the so-called student athlete. And they've tried to unionize, and there have been a bunch of efforts at that front of the students versus the universities. And so California passed a law which is fascinating. I don't know if enough has been actually written about it, but it was a unanimous. I mean, these days, not a whole lot of things pass unanimously between Republicans and Democrats. Now, you don't need to be unanimous in California. The legislature, the governor, I think every statewide office is held by one party. But nevertheless, this legislation was unanimous. And what it allowed was, or what it allows, I think starting in 2023, the student, the athlete, depending on your point of view, can earn, I think, can sell their likeness. For example, if you can sell a hat or do autographs and earn a couple of bucks. So it doesn't allow it doesn't allow the university to pay the students, but it allows them to get an endorsement deal. So currently, the school will go out and sell, the athlete's jersey or the jersey with the athlete's name on it, or sell a picture or do a video game deal that includes those athletes' likeness. The school can get paid for that, or the NCAA, depending on the rule of them and the conferences. But the student athlete cannot earn a single dollar, or they lose eligibility. So now, starting in 2023, the California athletes will be able to earn a couple of bucks. I think that will completely change the landscape, it seems, because, well, it probably won't change anything for the USC players.
But Notre Dame. Now, when Notre Dame plays at USC, do they?
So I had to say that as a former UCLA Bruin. So, you can imagine who I'm going to be rooting for on Saturday. No, in all seriousness, it's an important bill and a serious bill because California is a huge market. They have some of the best schools there. Of course, the top of that is UCLA. Then you got Stanford and Berkeley and a few others, Caltech. And you have, what is going to happen is that unless other states also allow that, what do you think the next, a great athlete coming out? One of my, as I was growing up and going to college, one of my huge pet peeves were, folks, players who Southern California lost to Duke in basketball. I mean, you had, Jay Billis and Mark Allery and Christian Leitner. And I mean, there's no reason why those folks shouldn't have played at UCLA. But Duke, Coach K was incredibly successful to attract them. And I know I'm dating myself with those names, but those were some legends back then, and they still are. Jay is a huge analyst on ESPN now. But what's going to happen now is if you have the choice to play at, Stanford or UCLA or Berkeley or wherever versus, Florida, Duke, or Notre Dame, and you can, if you're good, you can earn a few bucks in California. Well, where is that student going to go? So either California schools or Alabama. And that was a joke, Alabama. So what's going to happen now is, I think if that law stands, other jurisdictions are going to begin passing similar laws, or that rule just will have to go away for the NCAA. I think that's the practical effect. It has nothing to do, that's just actually the forces of competition at play there. I don't know what will actually happen from antitrust. I know that the NCAA has said that they would not allow any of the California schools, if that law is still in effect, to participate in any of the NCAA featured, like the tournament or other games that they might have. That would be interesting if there's a group boycott, but we'll see what happens.
Yeah.
But that's, competition in public policy that will actually force competition in the league.
Exactly. So we have a lot of our future criminal prosecutors in the room, a lot of people interested in criminal law. Antitrust leniency programs have been around for, for several decades actually, but your leadership has led to a major change on criminal enforcement of antitrust laws, with not only having the leniency program for, the one company that comes in to admit that we're price fixing together with a group of other companies, but now you're also introducing this idea of a sort of a credit for a compliance program, right? A compliance program within the company. So can you talk about that? What was your motivation to do that, and what's been the reaction from the bar?
Sure. So one of the most successful prosecutorial tools we have for criminal antitrust, and criminal, just to cleave off criminal as opposed to monopolization of different types of antitrust enforcement, criminal falls into the bucket where there's largely about 3 types of activities. And this is where horizontal competitors agree amongst themselves to either fix prices, divide up the markets. So, you'll get west of the Mississippi, I get east, allocate customers, which is a different flavor of the market allocation and market division, and bid rigging. So when when you're bidding in an auction for a product or a service or a contract, competitors agree amongst themselves, hey, we're going to agree, we're not going to bid more than, $500 on this, $2,000 TV at the auction. All right, are we all in agreement? And whoever gets it will get the 500, and we'll, divide up $100 amongst, the other 4, and we'll all end up better rather than bidding up to what the market price of $2,000 might be. So that's the type of activity that we're talking about. And there's, it's quite active. I mean, we have over 100 sitting grand juries right now that aren't public in this type of activity. And we're having yet another initiative announced to continue to enhance that in that area next month. But we are what we do. So for 25 years, we provide absolute immunity from criminal prosecution to anybody who comes in to the Justice Department and brings to our attention evidence of the cartel activity. And the theory behind this, and it started largely in 1993. And the theory behind it was there's no honor amongst thieves. And as distasteful as it might be to give immunity to a criminal, without it, we wouldn't know about it. So it was a way to bring these types of activities to our attention. And so we've had, multiple cartel cases. Some of these have brought in billions of dollars in criminal fines, and months and months, if not years, of jail time for a lot of these folks. Because of that immunity program, there has been this view that if corporations have a compliance program, our policy had been at the charging stage, to not credit a compliance program companies have. So corporations have compliance programs for, various types of activities, securities, training, Foreign Corrupt Practices Act, False Claims Act. Those are the types of issues that companies could trip over. And so they have a number of compliance, and different parts of the Justice Department would give credit, to encourage more of the compliance system within the companies. So the Antitrust Division of the Justice Department's view had long been that we want to maximize the amnesty program that we have to allow the person to come in. So we don't want to diminish that incentive in any way by providing any credit for compliance. And as we studied and heard from some experts and there's a phenomenal professor at Harvard whose name escapes me right now, who wrote a book on compliance and came into the Justice Department and spoke to us. And we talked to various stakeholders and looked at the criminal division's compliance program and others. We thought that, you could still have that maximum incentive. However, it could very well be a role for a robust compliance program, as long as it's working well, where the compliance program could itself manifest, this harmful activity that might be going on. So you might have 100,000 employees, and there's 5 of them in some sales division who are fixing prices on one of the products, and we don't know about. But sometimes they may not even, they may game the system and wait till the statutory period is over and not come to the Justice Department, because not only, are there criminal penalties, there's also treble damages for civil penalties that go along with this type of conduct. So we studied it, we held a workshop on it, and then in July of this year, we announced that if you do have and we laid out the number of principles of a compliance program that would be needed, with the thought that we will be able to uncover more of this by encouraging good corporate citizens to have that. And then we would consider that and give a deferred prosecution agreement to those who come in to tell us about activity that we don't know about, because it'll also help us, identify the other co-conspirators. So that was the concept behind it. That was the thought process, and the response from not only the plaintiffs and the defense bar and the academic community and within our division has been incredibly positive on all fronts.
Yeah. So let's talk about big tech. It's been in the news a lot. There's a lot of stories focusing on renewed investigations of various big tech companies. You issued a press release in late July saying that you were going to begin investigation of search, social media, and some online retail. So can you just give a little bit of a sense of what your concerns are and why the renewed emphasis on big tech?
So let me preface, as far as publicly, I won't speak on any individual investigation other than refer you to the press release that we had out there as far as that we're reviewing conduct. So we have heard from all corners of the public, competitors, consumer groups, and others, that there is this broader concern about a handful of companies that have a huge market share and market power, and they might be engaging in certain kinds of conduct that could violate the antitrust law. So we have a duty to examine that, and we have embarked on that. There's a big debate about that going on, not only in the United States, but in Europe and Australia and other places. And the state attorneys general also have engaged in an investigation of some of the technology companies. So we just want to make sure that, the right incentives are there for the next entrepreneurs to come in and the marketplace be free from any kind of anti-competitive conduct. I gave a speech in June of this year that I gave remotely by video, but many people view it as a Tel Aviv speech that laid out a number of issues and goes back to Microsoft case, IBM, AT&T, and another number of cases that lays out the types of conduct that the antitrust laws are capable of addressing. And that's the type of conduct we would be looking at. I believe it is public because the company under SEC rules made it public that we had made some requests on Google as one of the companies that we're investigating. So that one I could just confirm because it is public.
One of the things that you've done that is truly unprecedented, it's amazing to say, we've had assistant attorney generals for, decades and decades, and Makan Delrahim has done something that no other assistant attorney general has ever done. And that is to be creative about how to challenge a merger in the context of enforcement through not litigation, but arbitration. So for the first time ever, we have the Department of Justice challenging a merger through arbitration. Can you talk about that? I obviously am a big fan of this idea because I teach international arbitration. But tell us what we were thinking was and what the reaction was of the merging parties and where the status is of that.
Yeah, and thanks for your contributions when you were there to this. So we have a lot of times mergers could come down to a single issue of a debate of what is the market, what is the economic market that we are looking at. Is it, let's say that let's just hypothetically assume that there are two electric car companies and they decide to merge. And in that merger analysis, should the market that we are looking at be electric cars? Or should it be all automobiles? Or you can even be really creative if you're on the defense side, all modes of transportation. Because if you look at, all modes of transport, let's just take that as an outlier, but don't be surprised if defense counsel present that. Oh, it's just a mode of transportation. So if you're looking at mode of transportation, you look at airplane, bicycles, and motorcycles, and cars, and boats, and whatever. And you go, okay, well, the market share of these two electric car companies is, 0.002, and therefore they won't have any power to affect prices or output in the broader market. So the broader that market is, the better it is for the merging parties. Now let's shrink that. Let's say it's automobiles, and we look at, the automobile market, all automobiles. So leave out the boats and the planes and the bicycles. Now you got a smaller market, but let's say that those two electric car companies each have a 2% market share of the whole car market. So now you're looking at, combined, this is 4% against 96%. So you got a lot of competitors. Do they really have the power to raise prices ultimately to the consumer? Probably not. But if you define that market that we're looking at as just electronic vehicles, and because for a number of econometric reasons, that's the market. If somebody who wants to buy an electric car, if the price is too high, they just won't buy a car. That's the only car they want. They're not going to switch over and buy a combustible engine car. So that's what we look at. We look at substitutability and the consumer choices and a number of factors that with our economists, we define what the actual market is. So if it's now electronic vehicles, you're now going from, let's say each of them have 2% of the car market and they're the only two players. Each of them have 50% of the market share of electronic vehicles, and they're together going to have 100%. So that means together now, right now, those two car companies are competing for that consumer who wants to buy an electric vehicle. And if the two of them together are only selling the electronic vehicles, they can raise prices, and your only choice is to go to that combined company. So a lot of times, mergers are not that easy, but I was using that as a hypothetical example to prove the point. It becomes, what is the market definition? What can we prove the market to be? We have this merger of Novelis and Alaris. These are two major global international manufacturers of aluminum. And one of the areas of aluminum is, these are called aluminum body sheets. This is a high strength aluminum that is just as strong as steel. It costs a little bit more, but it's being used by car companies for certain parts of the automobile. So let's say the hood or the doors or the hinges or whatever, in order to make the car lighter to meet efficiency standards. So it's an important part for some cars. The issue is, should the market we're looking at this aluminum body sheet because of its special characteristics, or should we look at steel as part of included in that market? So that's the big fight, and the legal case will fall or rise with just the determination of that market. In this case, that was really the big issue. We believe in our definition, we think it is the narrower one. It is a more accurate way. All economic data and evidence over our investigation shows that in and of itself, it is its own market. The defendants don't agree. And so we said, all right, this is one issue. Instead of going and litigating this for, months, perhaps year or two, you go to a generalist judge, who needs to be trained up on the economics of this and present evidence and third-party evidence and highly paid experts on both sides. And he is like, I don't understand this. I have to look through a crystal ball to figure out what the heck this is and what a future, car company may buy, may not buy. And it becomes a difficult issue that lends to a lot of uncertainty. And not only the uncertainty and the outcome, but in the time. I mean, the judge could sit on a decision for 6 months, a year, and not know what it is, and you got appellate rights. So this thing could drag on, and the business uncertainty, becomes a real issue. So I proposed to the parties, I said, hey, we know where we are. You guys know what this is. We know what this issue is. Why don't we cabin this and arbitrate this? We'll let us both identify, a retired judge who actually understands antitrust law, or a professor or a former enforcer or practitioner or an economist or whatever, that assuming we can agree. And the two of us will have a process by which we can agree. I mean, arbitration isn't new, might be new for the federal government, but it's not new. So can we figure out? So we embarked on a process to see, can we do this? So the parties came back, and their concern was, hey, we want to be able to have third-party subpoenas that you would get in a court system. And we began looking, can we do this? The Justice Department can issue CIDs, but, can we allow them to piggyback off of ours? And we went back and forth. And then lo and behold, one of our front office counsels identified a law that Congress actually passed in 1996. That is called the Administrative Dispute Resolution Act of 1996. And Attorney General Janet Reno had actually issued regulations on this to the Justice Department. And my predecessor, Ann Bingaman, had also issued some comments about it. So it laid there. I don't think a single lawyer or practitioner, probably even, or academic, I don't think that law had ever gotten a hit off of, whatever, law.com and Lexis.
I never heard of it.
And you teach this stuff, right? So it was fascinating. So we said, oh, look at this. It provides, it actually anticipates a lot of the issues that would come from this. So we began looking, proposed it to the parties, and we entered into an agreement. We filed a suit with a term sheet and the idea that we would refer it to, if certain things don't happen, we gave them a chance to resolve the concerns by selling off a plant or two. And if it didn't happen, then by a time certain, we would refer it. I am pleased to say that we have identified an arbitrator now. We actually have a case management order in place. Come January, it would kick in, and it would be the first time. And, I think everybody will learn. What we did do, we agreed that we're going to, once we select an arbitrator, here is, the limits on the number of, custodians and others that we would be able to seek discovery from. The arbitrator would have, I believe, we said, 14 days, but, somewhat of a mini trial before the arbitrator. He would have, I think, 14 days. I forget the exact terms, to come up with a ruling. So we know that there's a finite time that we will have, but more importantly, the business community will have to resolve this issue. And there's, this is a multi-billion-dollar merger that, this is one component of it. So they actually have the certainty for their investors, for the capital markets, for everybody else to be able to move ahead. And I hope it becomes a model, if it's successful, both for the division to protect the public and consistent with our enforcement mission, as well as for the business community. It could be one that could be a model for the future. So I'm hoping that it's one of those innovations that doesn't go back on the shelf.
So we have several students that have been interns at the Department of Justice, Katie, Devin, others. Can you talk briefly about having a career at the Department of Justice and why students should consider doing that?
Sure. I think it is, well, first of all, the public service. I've been fortunate enough to have had a chance to be in all three branches of the federal government, and have loved it. So I encourage you to try all of it, partly because as we all grow, we don't really know what it is that really motivates us and excites us. And I think there's no career, no matter how much money you're being paid, is worth it if you don't enjoy doing it. So the most important thing, as you guys are thinking about your future careers, is to find something that you really like. And today you might think it's something. And a year from now, we all change, we all evolve. We don't know exactly what it is that excites us. And so the government provides that opportunity. But more importantly, I think just the public service, working at the Justice Department, there's no place where you'll be able to be a lawyer, be around some of the most dedicated, some of the most talented lawyers who have ever gone through these fantastic law schools, to come in and practice what they absolutely love and to learn from them. You can maybe go out in the private sector or whatever you wish to do, but at least for a few years, I think there's no better time spent as a lawyer developing your skills in the government, perhaps longer. And there's no feeling better than to stand up in court saying you represent the United States. May not be as lucrative as you standing up and saying I represent, Ford or Google or, IBM or whatever. But it is no better thrill, and you'll have some of the, best opportunities to do that. So we have the SLIP program for the interns, the honors program, post-graduation or clerkship. And there's always lateral opportunities. And the Justice Department is not just the Antitrust Division, but U.S. attorneys across the country. Many folks have geographic limitations, but I would highly encourage that.
Okay. Good. We're running out of time, so maybe take one question from the audience and then we'll wrap up.
Sure.
Anyone? Yep.
It's kind of a two-part question, so can I cheat a little bit. But prior to creating the incentive for the compliance programs, how did you or your predecessors square that with the organizational sentencing guidelines? And then the second part would just be with regard to compliance, being so late in the game. I'm curious if y'all are following your colleague, Assistant Attorney General Ben Kasowski.
Menchikowski.
Yes, thank you. His guidance on the use of monitorships.
Quickly, the first one. So we, through the sentencing guidelines, we did factor in compliance, but it came at the sentencing side, not at the charging stage. So this policy, what it changed was to do it up front and to be able to credit it for the charging as opposed to sentencing only. The second, as far as monitorships, we have different, partly because we have different uses for monitors. Sometimes, particularly in mergers, we want folks to be able to, it's not just so much for corrective mechanism, but going forward, parties make certain commitments, and we want to ensure that it goes forward smoothly. But on a number, as far as like selection of monitors and all of that, we apply the similar standards with our friends, the criminal division. They also just recently issued, some guidance on inability to pay by parties. Parties always come in and say, I'm not able to pay this. If I paid this, fine, I'll be bankrupt, or I can't pay the private plaintiffs. But those are just very, they get fancy lawyers, $3,000 an hour to come in and argue for 6 months, a year, that they couldn't pay a couple $100,000 fine. So, but we factor in according to the law. You had a question there, so we can, if your time allows, we can allow.
Sure.
Go ahead.
My question was about the timeline in which you sort of restrict a business that has carved out market share. I'm going to use the Google situation, but you don't have to answer it in that context, because it didn't start as the only search engine. There were several others, and then it sort of over time developed and matured before you sort of sought to restrict it. And Bing is technically still out there, though people are self-selecting to not use it. So my question was where that line is for you, where business is like overstepping its bounds.
Let me see if I understand the question. So is it about the time of the conduct that is going on before we take enforcement action?
Yes.
It's one of the challenges, I think, of antitrust law in general, particularly in dynamic industries that are fast moving, is that at what time do we enter in? We have to meet, in our system of law here, we have to go to a court and prove our case. And so we have to gather enough evidence of the conduct to be able to do that. So sometimes the companies who may have been victimized by the type of conduct come in to the Justice Department and complain. Sometimes they bring private cases, and we, engage in the investigation. Does it always remedy the harm that went on before that? I'll point you to the Justice Department's actions in Microsoft 20 years ago. I mean, those allegations of what Microsoft did went on for, at least a decade. I don't know how many companies and how many employees and venture capital money fell victim before there finally was a resolution, ultimately, in that matter. So it raises an issue of the broader process of how quickly can antitrust solve a broader problem. So
Great. So let's thank Makan Delrahim.
thank you very much. Thanks so much.
Thank you.
Thanks for having me. Thank you again, Katie.